So good morning. I hope you're having a good stay in Israel. You still have one or two more days to see the rest of our beautiful country. GKH is one of the leading law firms in Israel, deals in all fields of law. I'm a partner in the venture capital, M&A, and high-tech department. We represent clients in Israel, all around the world. We represent high-tech companies. One of them you met yesterday, Orbs. This morning you're going to meet two more, which will present themselves to you. Mobile Bridge is also one of our clients. I'm a great believer in the product. I believe they will succeed very well in the ICO. We all hope so. I would like to introduce to you Shai from my office. He heads the blockchain department. Just a few words about Israel, the blockchain Israel. Shayanovsky.
Thank you, Steven. Good morning, everyone. So my name is Shayanovsky. I've been 10 years in the firm. I'll start with just a small presentation of our office, and then I'll jump into the blockchain field, which me and a colleague of mine, his name is Sharon Kadosh, are leading. As Steven mentioned, it's one of the Israel leading law firm. We're having a lot of multinational clients, and we have lawyers who also have U.S. practices in the U.S. stock exchange. We have a secured and established science practice. It's the idea of our office is to be a one-stop shop for all clients, meaning it can be from the corporate level, employment issues, tax issues, etc. We have over 250 employees, 170 attorneys, and 60 partners and 30 interns. I know in Israeli terms it means big, and in other practices maybe not. We are part of the high-tech and investment funds practice area, and we're representing clients in various fields, including in cyber, semiconductors, blockchain, which is my field of interest, IoT, AI, autonomic vehicles, AR, VR, mobile and digital, AdTech, FinTech, Big Data, etc. This is just part of the clients that we're representing. Actually, I've just met you downstairs, and I saw that you used Get Together, so Get Taxi, which is kind of the Israeli Uber competitor, is a client that our firm and myself represent. So I was proud to see the logo of that Get Together when you were going downstairs. These are part of 2017 transactions. You can see the China merger with Mahdashim Agan in transactions worth $2.4 billion. Converse acquisition of assets by Amdocs. I was part of the team that was representing Converse, which is now Mavenir, in the sale of assets to the whole actually billing department to Amdocs, and there are many others. Just because of the time, I wouldn't go through all of them, but this is just part of what we do. Regarding blockchain technologies, so just to get a sense, I understand that this is what you're interested in hearing. In terms of technical background and blockchain, there's nothing. I shouldn't start with the basics, right? You're familiar with this. All right, so I'll jump for this whole. First of all, we're lawyers, so it's not that we really understand what we're talking about when we talk about technical issues, but a lot of what happened in Israel was kind of educating the market as to what is a blockchain asset, what is cryptocurrencies, and the bullets that we're seeing here is just in a way how we kind of translate the technical language into legal principles, which is first of all the decentralization and the fact that it's hosted on distributed ledger. This, for example, represents a complete difference than how regulators here and abroad look at databases. If we look at, for example, the GDPR regulations that we have now in Europe, it all comes down to the fact that there's a main entity that holds all of the data and it is responsible for the data. It's against the principle of blockchain, which is that the data is distributed everywhere. Other issues as well with the GDPR, for example, GDPR the GDPR regulation states that the database holder, the processor and the operator of the database needs to delete the data after it's been used. But in blockchain, as we all know, data is never deleted. It's just blocks and blocks and blocks. So there's a lot of issues with regulation. No trust of third parties, centralized database, I just talked about it. Fact of mass collaboration, removal of infinite reproducibility, meaning, with the digital assets until blockchain was made, it was duplicated all the time. So that it would have been hard for a digital asset to say this is the owner of the digital asset. Now, with the private keys and with the fact that we have a way to identify someone who's holding the assets, this is a game changer. Transactions and blocks and data incorporability, of course, are also important issues. Here we see some real-world uses cases. It's very, very little from this slide. It just shows that there's a lot of use cases. But we can think of almost every industry are now looking into. I spent yesterday with orgs. So I guess you've dived into various practices that blockchain can replace the traditional platforms. But we can see, for example, it's very little, but diamonds. So the beers here. We have. We can of course send you the slides afterwards, so you can look into it. But there's tourism, national security, energy, waste management, etc. So there are many different use cases. This is a map of the Israeli blockchain startup landscape. So it maps by verticals. So we have the fintech industry, for example. There's Kolu up there, which is we represented the investment of IBI in Kulu, which is a way for small and medium businesses to have transactions, for example, in coffee shops in Tel Aviv. It's going very well right now with a digital wallet. So the one sitting in the restaurant can pay via the mobile and not with credit card. Doesn't need any wallet, anything. Just shows the cashier that the transaction was made, and this is how it goes. So they now just a couple of weeks ago issued a cryptocurrency for Kulu. Very interesting stuff.
Where is that located?
Kulu? In Tel Aviv.
I know. How far is it? She may be interested in going there and shoot it.
I can check for the address afterwards. Kulu. Just one of them, really. There's many, but just one option. You'll see one of my clients who will come at 10 is and is also very interesting to talk with is developing a blockchain platform for trading real estate. Also an interesting use case. With respect to smart contracts, so again, the role of lawyers will definitely changed. I spoke at the Israeli Bar Association a couple of weeks ago about how to be prepared for we call it the smart contracts revolution, and what will be the role of a lawyer when there's a smart contract that will replace most of what we do. One of the jokes was that lawyers really always use the term and or. So this will, in a smart contract, if you say and or, it will lead to an error because there's either and or. And it's an example just to show how it will be much more like a computer code and less room for interpretation, different interpretation. I believe that a lot of us will need to learn software coding, but others will definitely be in the field of being the human factor behind the computer to explain to the clients how to structure their contracts. But again, there's many interest from regulators as well. We see it a lot in Israel of the benefits of having a smart contract replacing a lot of the registries. For example, again, going to real estate, the real estate register, the shareholders register, other registers as well, because of all of the benefits that we can see here, the autonomy, trust, the issue of safety, backup, speed, a lot of intermediaries in the way. When there's a lot of human factor in the way, and there's room for human error, definitely a smart contract would be a right solution. Of course, there are many challenges. I believe it will be the next slide. IPO, I will jump over it. We just go to the legal framework. I will of course talk about ICOs, but it's in the legal framework. So from a legal framework point of view, we are in the room of uncertainty, like many other jurisdictions as well. The uncertainty is coming both from the Israeli Securities Authority point of view, also from other regulators such as anti-money laundering regulators, the tax regulators. Many try to figure out what exactly is a crypto asset, and where we define it as an asset or a currency or a security. This will of course change the picture for all players in the market. So we are in close contact with the regulators that have drafted drafts and bills circulated around. There are roundtables that we're taking part of. It's still very, very unclear what would be the regulator point of view in each scenario. What we can basically say is that while the issue of ICOs, which I will talk about in a second, raises a lot of eyebrows in Israel, there was no doubt that blockchain as a technology should be promoted. So the issue of raising money through the platform with or without proper disclosure to the market and while following the Israeli securities law, this is still questionable. The issue of having startups developing blockchain in Israel and keeping the technology in Israel, meaning not just developing it and having an exit and fly away, is something that everyone wants to promote. So the question is how, not if, but how. So first of all, there's the contractual level. Okay, if there's a distribution of tokens or sale of tokens, then there's of course a question of consumer protection law. Okay, I promised that with what you purchase you will get X, Y, Z. At the end of the day, I didn't deliver, or I didn't deliver differently. There's issues with the contract. And this is doesn't matter if it will be deemed as a security or not as a security. This is basically just the fact that I had a website, I published on the website. I'm developing a blockchain platform for I don't know, for using computer resources of others in times that they're not using it. So something very, I think one of the initial implications of blockchain was to allocate resources. Like for example, if I'm going to sleep at night and I leave my computer open, then someone else can use it to mine coins. So this is let's say that's the example. At the end of the day, someone raised this money and didn't deliver the code, or at the end of the day, I'm left with a token that is worth nothing, does nothing. So there's definitely an issue here, because under securities law, there's a certain procedure that I need to go through. I need to go to the to the Israeli Securities Authority, approve a prospectus in advance, and then I get a permit, then I issue, then I can go to the public. Here, like I said, it's very unclear what will happen. There are many issues with consumer protection regulation. This is why the white paper, this practical best practice that issuers do now, needs to be very carefully examined also from a legal perspective point of view, to see that the language there and the disclaimers and everything is well covered, so that people will not promise.
White paper is very ambiguously, so that they not be in trouble later, right?
Definitely. Definitely. I can tell you that the white papers that there's been a huge jump. I would say that 2017 was a year of game changing in the fact of, beforehand there were ICOs that were promising, to those who purchased the tokens, things that definitely are not achievable. We will be the first leader in the world of this and this and that. After lawyers started getting into this and say, hey, you can't promise something you cannot provide, then the white papers started changing, and now the white papers are much more balanced and have, they do. There are other issues with white papers. It's a good question, so I will jump to it.
It's still not clear. Even today, it's not that clear.
Yeah.
For the investor point of view.
Yeah. I would say something else about white paper. Exactly. White papers.
What wasn't EOS like the best example? And then this software does nothing, has no purpose, entitles you to nothing.
But then, why should I invest in your software?
Well, that's not the question. I mean, the point is like the white paper was like every possible disclaimer you could think of.
So you're looking for an example for this, or just?
No, my question isn't that the best example? It promised absolutely nothing.
Yes, but there's a balance you need to do. Okay, if you do it this
What
way,
do you mean a balance?
You want, on the other hand, you want to encourage a community that will purchase your software server, right? So if you will say
so.
this is nothing,
they brought in $4 billion.
for nothing.
For nothing.
When
You
say,
don't know about EOS?
of course I know. No.
Okay, they raised $4 billion. The white paper said, we do nothing. We offer you nothing. There's no promise.
Yeah. Okay.
It had been done like that, but now the investors are asking for and demanding for
Exactly.
Thompson conditions and plus ransom warranties.
Yeah.
That's the difference.
I haven't
The
seen
market,
any.
what I'm saying is
I
the
haven't seen
market
any
is
demand.
maturing. I agree with you
It's
that you
coming
can take a lot of examples from 2016, 2017, that there've been cases like this. There's also, at that bar association, there was also a presentation of someone else that showed how quickly people raise money this way, and it's been like, I think that the record was something like 30 seconds for millions, for so it was unrealistic. But we do see, like you said, we do see maturity now, and much more balanced white papers that, on the other hand, do promise some things, okay, and I'll explain why, but on the other hand, gives, like I said, pillars, reps and warranties, and are very balanced in what they do and not do. And the thing is that at the end of the day, the white paper is not just examined by the token purchaser, but also by the regulator. And the question would be, let me see if I have the slide. The ISA's committee report from March 2018 said that it's a case-by-case examination. They will look into it and they will see whether, when you issued the token, you promised the purchaser profit, rights in your company, secondary market that will be trading the tokens. Okay, all of these are signals that this is a security, and it's not purely utility token. That the whole intention was that someone will purchase the product or service. Okay. So
Is this similar to the Howey test?
yeah, it's taken from the Howey test. It's taken from Dow and other and Munch's examples, but it's I would say a development of this test, because the Howey test basically leads to, there are almost, I'm not aware of any places where there was a way to pass the Howey test and say, okay, this is a purely utility token. Basically because it's a chicken and the egg kind of problem, okay? Because when you're developing the platform, you still don't have all the funds and all of your ways to have someone that purchased the tokens at the day that he purchased the tokens to already execute what he wants, okay? So it's a kind of a chicken and the egg problem. So this is a bit more balanced way to look at it, but still, it's in draft form. It's still was just published for the public comments, and it's at the end of the day, it's a case-by-case examination, which is problematic for us lawyers, because if we need to give an opinion for a certain company to say your token is a utility token or security token, we cannot guarantee, because we don't know how the ISA will, at the end of the day, the ISA is the Israeli Securities Authority, will look at it. But back to the test similar to Howey is whether at the time of issuance of tokens, the token had the ability to have a utility for the platform that I'm using. So it needs to be purely platform. It's not that I'm using the blockchain for other industries. Let's say I'll take the diamonds example. So let's say I'm a diamond trader, and I want to raise money for my activity as a diamond trader. So I use the blockchain network. That's not something that they will look at as positive way. What they need to see is someone who's what he has is a pure platform blockchain, and in order to have a community that will support this blockchain network, they will use the tokens, and that there are mechanisms to ensure that the tokens are not being traded afterwards. All right, so that means that someone who initially purchased the token will not purchase it for the purpose of making profit by selling it to other. He will actually want to, she or he of course, will actually want to use it afterwards for the product or for the service. So if we take the example of the resources, it will be, the token will enable you having like 100 hours of credit for each token that you purchase, something like this, but it will not grant you with any profits from the platform itself. Okay, understood? Yeah.
So there's a distinction I've been seeing about, like, for example, during the sale, maybe a company acted like a security. Maybe after the sale, before the product launch, they act like a utility. Maybe after the product launches, they act like utility. So there was this view where, like, at a different point in time, a project was acting like a security or like a utility. So is that a view that you're taking as well, in terms of different moments in time?
Yeah, first of all, I agree completely, and it's a very good observation. In different points of time, I had it in the Bar Association slide, but not here. I have actually a timeline that I use arrows to see how in in a pre-sale stage, a sales stage, after when the product goes live, when the product dies, in different stages of the company, the utility, the token can be deemed as a different type of token and grant different rights. I'm personally aware of people from the industry that raise these claims towards the regulator, and they're examining it. For example, to say, okay, so it's not a security, it's not a utility, it's nothing that we ever dreamed of or think of when we regulated the regulations back in 1969, I think. It's a hybrid kind of instrument, and we need different separate rules for it. So it will, when it acts like a security, we will impose certain principles from a regular security point of view. When it acts like a utility, we will treat it as a utility. It's questionable. By the way, there are companies that issue different types of tokens for different reasons, and they say we will deem this one as security, we'll deem this one as utility. And there are also other companies that say, okay, let's say, you know what, I agree with you, it's a security token. So I will follow the security rules in full. I will, for example, issue it only to accredited investors. Right? So I don't need a prospectus for accredited investors. I will follow any step of the way. I wouldn't be treated as something dodgy. I want to be completely white, and you see this as well. We have a very problematic issue with taxes that was still being examined, which is there's a tax position that says that cryptocurrencies should be treated as assets, meaning that there will be tax for each transaction. It's still being discussed, and there's still not a final wording on this point of view. And also from anti-money laundering legislation, there's a certain order that is still pending, but it will enter into force very shortly. It was, I think, in 3 months or so. As to the type of activities in cryptocurrencies that may be deemed as suspicious activities, so those who are dealing with cryptocurrencies in the market needs to take a good observation of these types of transactions. For example, if someone is paying me with cryptocurrencies but is using a mixer platform, meaning his mixing is IP addresses, and it will be problematic to look historically and see if this came from illegal activity. Then this is one of the issues that they're checking. It's also a good development from our end, because insofar the banks system and the banking system basically completely refused to open a bank account or respect a transaction that had any connection to cryptocurrencies in Israel. There's been a huge case with, I don't know if you met or heard the name Bits of Gold. Bits of Gold is an Israeli company that deals with trading cryptocurrencies, and it was a huge case that led all the way to the Supreme Court as to whether Bank Leumi has the right to refuse to open a bank account for Bits of Gold based on the fact that they're dealing with cryptocurrencies. It was the fact that it wasn't really determined what banks need to do in order to do it was kind of, I would say, an excuse. On the other hand, to completely refuse to any activities with cryptocurrencies. This new order, will give some comfort, because they know, okay, we will take this 37 activities that are listed there as as our guidelines, and we are anxious to see whether banks will pick this as a starting point and start working with good and respected cryptocurrencies companies. And therefore, Israeli companies that are dealing now with cryptocurrencies don't need to go offshore and open bank accounts and start having complex structures of companies just because they cannot have activity from their homeland. So this is, I think in a nutshell, this is basically where we are right now. A lot of uncertainty, but we do see a good direction. There are a lot of regulators and policymakers that we're meeting with that are positive about the notion of having blockchain as a technology. As I mentioned, ICOs is something that we less hear about right now. It got itself a bad reputation, a lot of fraud and a lot of transactions in 2017 made it a bit difficult to even to even raise the term ICO in front of a regulator. But we do see private offerings, and we do see what we call pre-sale, which is SAFT, which is something that I used until a month ago, but then again, it's something that we don't use the term anymore, but if you know this term, it's same as SAFE, which is an agreement for future equity, but just with tokens. So it says, I intend to have a public offering of tokens in a few months or so. In the meantime, I turn to you as a private investor and I offer you the right to participate in that future sale. So this is something that we do hear about. As I mentioned, we work closely with regulators and we are participating. We are foreseeing to see a lot of activity that is currently being done, and it's in a way it's hard for us Israeli lawyers to see a lot of good Israeli startups. We have Israel is what we call the startup nation. So to see a lot of brains in this field, just because regulations develop something and then fly away is something that is not good for the market. So definitely we do believe that we will see a lot of more certainty in the near future. Any questions? Yeah.
Thanks for kind explanation. I think in Israel, ICO is not permitted, right? So you go outside to Zug or Singapore to do the ICO. Is there any movement to allow that inside ICO in Israel? And if so, when do you expect that will happen?
Okay, so I jumped on it, you're right, and I said I would get back to it later, but I didn't, so good. In Israel, ICO, because of the tests that I talked about, is deemed. The question is, okay, let's say ICO, initial coin offering, meaning I'm going to offer a token. Okay, I'm going to offer you the right to participate, may be deemed as a security under the Israeli securities law, and it's not that it's not permitted, but in order to conduct such an ICO, you will need to follow the public offering rules in Israel, which means that if you are addressing more than a defined number of investors in a year, you will need to publish a prospectus that will be pre-approved by the Israeli Securities Authority and other regulations as well. So this is I guess what you mean when you say not permitted. So this is something that you don't want to fall into. There are other jurisdictions that you can do it. There are a lot of trends, like I said, Singapore, Gibraltar is one of them, Switzerland, England started lately. There are a lot of designated rules for conducting these transactions offshore. And yes, the whole purpose of the committee report of the ISA is to have the ground rules for having such activity permitted under specific regulations that will be designated for this in Israel. In terms of timelines, we don't know because this initial committee report it's very usually the way it works is that there's a committee, there's findings of the committee, then there needs to be the regulator needs to adopt the conclusion of the committee, and then it starts the legislative process, and there's a lot of issues with the legislation itself. So until we haven't seen draft regulations that will enable this, it will take some time. In the meanwhile, I believe that we will see some. We will have to see some other ways to do it that will not be considered as ICOs. As I said, the term ICO is something that is not being used. We will see ways to let's say if it's not raise money, but to establish a community and an ecosystem around a blockchain platform, which will not fall into these rules. This is something that we do see. Ways around the ICO.
What do you mean by the smart contract there?
Smart contract, meaning that there will be ICO is a way of a smart contract, meaning the token itself has conditions that will enable the utility of the token. So, for example, on Ethereum, if I issue a token on Ethereum, then I can say if I have by the date of I don't know what the launch, I have enough users and they reach this and this amount, then the token will be utilized and will accredit you with a certain amount of credit that you can use for your utility. So all of this is coded into the contract itself that you're purchasing. Okay?
Is it part of the token economics?
Yeah, exactly.
The quantities and how many is allocated?
Yes,
here?
yes, yes. The allocation of the token economics. I was missing this term. Yes, absolutely. Any other questions? Great. So feel free when you're meeting Israeli clients. If you have questions about the regulatory situation in Israel or any other thing, please feel free to contact me or Steven, of course, and we will be very happy to assist. Okay?
Okay.
Thank you very much.
You know that name?
이스라엘 다른 나라에 가서
We have Israeli exchanges.
Sorry?
Exchanges between exchanges.
Bits of code is